It's 4:10, and I guess we can start. We have quite a lot of attendees. So dear colleagues, hello everyone. We are very happy to welcome you at our investment arbitration coffee shop. And we hope you will stay with us until its end, which is quite soon, already in 50 minutes. And the conference organizers made a draconian threat to stop the session at mid-sentence, so we'd rather comply with timing. The idea of this coffee shop is to discuss the potential effects of the COVID-19 crisis in the context of ISDS, and what lessons can be learned by ISDS participants. Let me first introduce our esteemed speakers. You see Sarah Vasani, who is an experienced international arbitration lawyer and is the head of Addleshaw Goddard's investor-state dispute resolution practice based in London, if I'm not mistaken, Sarah.
Correct.
Okay, she also regularly sits as an arbitrator and is a panel member on the CR business arbitration scheme. Sarah is qualified in England and Wales and the District of Columbia and Texas. And now we move to Olga Boltenko, who is a partner with Fangda Partners law firm in Hong Kong. Sorry, Olga, if I pronounce it wrongly. You can correct me.
That's right. That's
okay.
Right.
She's also a very experienced investment and trade lawyer with over 10 years experience representing both investors and states in investor-state disputes and in investment advisory matters. Olga also acts as an arbitrator. She's qualified in Russia and is registered as a foreign lawyer in Hong Kong. And briefly about myself, my name is Olga Tsvetkova, and I have some 12 years experience with cross-border disputes. Currently, I lead an international arbitration team at the Russian Ministry of Justice, where I'm also in charge of investment disputes involving Russia. And prior to joining the ministry, I was a counsel at the Russian law firm EPAM. So before starting the discussion, we will make a poll now, and we'll ask you to answer a question, whether the ISDS system, the current one, is actually well prepared to adequately address cases arising out of pandemic. I'll start a poll now. Hopefully it will work. Okay, I launched it. And we will relaunch the polling in the end of the event to see whether, the discussion changed the opinion. And while it's simple, just one question with yes or no answers. And while you're voting, I'll just mention a couple of housekeeping matters. So this is supposed to be a live discussion. Please use chat. You already do, thank you for that, for any questions or comments. If you want to speak instead, use a raise a hand function. And if you want to be on video, put it in chat and we'll move you to co-hosts. So second, during the session, we may step into shoes of different ISDS stakeholders for discussion purposes. We act in our personal capacity, and any expressed views do not necessarily reflect our professional ones or those of our organizations. That's clear. And finally, all sessions, and that's important, are going to be recorded and posted to YouTube. So if you want to say anything provocative, please do, because it would increase our viewing numbers. So with that, I will now share results of poll. Share results. Okay. So I guess you see results, and it's actually quite equal number of votes, both favoring ISDS and being skeptical about it. That's good. Let's see what we have in the end. Okay. So what we want to discuss today states across the globe had to act and propose emergency responses to the COVID-19 crisis. They will likely be required to take further regulatory measures that severely influences international trade. Consequences of the struggle between public health needs and economy is still to be assessed. But what is clear already now that negative effects for markets can hardly be overestimated. I'll just show you 2 slides now. Okay, now this one, okay. The first one, so it's UNCTAD projected a negative impact on global FDI flows ranging from 5 to 15% in 2020, with the effect of the demand shock filtering in 2021. And then in terms of sectors, the hardest hit are transportation and energy and basic material industries. That's just some economic information. In that context, UNCTAD warned that although the measures are taken for the protection of the public interest and to mitigate the negative impact of the pandemic, some of them could expose governments to arbitration initiated by foreign investors. A number of investors have already made threats against some governments, reportedly against Peru and Mexico, to sue them. Why it matters? One can say that the world saw other crises and perfectly deal with them, including with the use of the ISDS system. One can recall like the Argentine crisis or the Arab Spring. But let's be frank, it has been long, if ever, since any other crisis had such global effects on almost each and every industry worldwide. Previous social cataclysms either concerned specific separate regions or industries, which made other actors quite unconcerned, or at least less concerned. The pandemic triggered a truly global crisis, the depth of which we can just not assess it at the moment, and which required such extraordinary measures as mass border closures and travel bans that the world has not seen for long. Both states and investors now need to find ways to adapt to the new circumstances. And it is not only a question of dispute resolution, it's actually equally concerns future investment planning by business and policies management by states. And tribunals play an important role in finding a new balance. So a more general issue is how to start driving things towards more consistent framework across the world. For example, Russia has recently approached UNCITRAL with an initiative to establish a separate working group that could deal with the pandemic consequences and develop more predictable legal environment for international trade. But it will take time. Meanwhile, we get alerts from law firms on how different measures could be challenged using treaty-based ICDS. As also evident from previous crises and case law, various regulatory measures taken by states in extraordinary circumstances lead to a rise in investment treaty claims. So Sarah, and I have a question to you. Should states expect now an explosion of claims by foreign investors due to the COVID-19 fight? And what are most likely scenarios in your opinion?
Sure, thanks very much, Olga. Well, I think you hit the nail on the head when you noted all of the different alerts that suddenly came out by law firms after the pandemic started. I guess there's always an upside. There's a rainbow at the end of every cloud. And I guess for lawyers, it would be that potentially there's no more new disputes for us. And as lawyers, we love to have more work coming in and more disputes. I think by and large, this talk about mass claims in light of COVID-19 is overstated. I think certainly there might be some claims, but I don't think we're going to see the type of mass claims arising out of them. And that is because international investment treaties, while on the one hand protecting investor rights, they also allow states a scope of movement when it comes to policy and especially legislating in the public interest. And I think it would be a very difficult case to make that states weren't acting in the public interest when they made these cases. Now, I think really there's two types of claims. And first, what I'll do today, I'm going to try to canter through this quite quickly so that we can have more discussion than not. And I'm sure most of our audience is familiar with a lot of the investment treaty standards. But I think there should be a distinction between host governments who are using measures to specifically address COVID-19 and the health pandemic, and those who are using it as cover. So those who are using it in order to get something passed that they always wanted to do, and now they are doing so under the guise of COVID. To give you one example, and I don't think this will result in an investment claim, but I live in London, as Olga mentioned, and London is notorious for its bad traffic. And Boris Johnson, former mayor and now prime minister, has always had a thing for biking, although you probably wouldn't know by looking at his physique. And he has used recently this COVID as a means of clearing additional bike lanes, which has the taxis and the trucking industry quite upset. But this is something he always wanted to do. There was always a lot of pushback, and now he's implementing it in the context of COVID-19, saying that more people should bike to work, so let's just clear the roads of cars and move towards biking. So I think when you have a situation where the host state is using a COVID as a guise to do something else that it's long wanted to do, then I think you have an issue. But by and large, states do have a relatively wide range to regulate. With that being said, I might just move on and quickly go through the types of claims that might arise out of the pandemic. And Olga, if you wouldn't mind going to the next slide. So as Olga had mentioned, and I'm dealing with two Olgas here, so I can say that to either one of them and be okay. There has been quite a lot of discussion about what measures and what actions that states have taken might lead to investor state claims. And to be fair, there have been a lot of quite drastic measures that states have taken. For example, a lot of states, not just Spain, have taken over hospitals and cleared out private hospitals to be used in the public interest, and by creating separate COVID facilities that would merely deal with COVID patients. This, in the meantime, has meant that operating rooms can no longer perform the for-profit operations that they might otherwise undertake, and there will certainly be economic harm to those doctors and those hospitals having to put everything on hold. In the US, under the Donald Trump's administration, they have converted a lot of manufacturing facilities to make PPE. They've also done, this is done at both the state and a federal level. Then we also have seen in the UK, the renationalization of certain rail franchises and the payment of state aid to airlines, and also restrictions on imports and exports. And notably, India had a major export controls related to the pharmaceutical industry and blocking 32% of pharmaceutical exports, which is a large export industry for India. So the idea is, will mass claims arise from these measures? And as I indicated, I personally don't think so. There might be some cases, but not all. And with that, perhaps we just move on to the four umbrellas under which these might come out. The first is fair and equitable treatment. If we move to the next slide. FET has really become the most invoked substantive standard of investment treaty arbitration. And really it encompasses quite a great deal of different aspects or different strands, as we refer to them. The basis, and I think if you go back once, the basis is really legitimate expectations, and whether or not an investor's expectations when investing in the host state have been met. Now, the issue with the pandemic is, does an investor really have a legitimate expectation that a state isn't going to take drastic measures in response to a national health crisis? And I think the answer to that is most likely no, it doesn't have a legitimate expectation. Now, the state still has a duty to act fairly, to act with due process, and to ensure that its measures are proportionate and reasonable and non-discriminatory. But overall, a state certainly has regulatory room to act when it's faced with this type of a crisis. I also note that unlike the Argentinian crisis, with which Olga referred to previously, that crisis was arguably Argentinian made, whereas this is not a crisis that is discriminates. It is everywhere. It's constantly ongoing, and there's very little that states can do to protect themselves from the pandemic. So it's kind of so pervasive on a scale that we've never seen before that it, I think, makes states much more reluctant to condemn any other states about the measures they have taken, because so many of them have been forced to put into place significant severe measures in a very short period of time. Applying some of these COVID situations, some places where there might be a little bit of more of a justification for a claim might be, for example, if there was a lack of transparency. It was kind of famously noted 2 days ago that Donald Trump intentionally downplayed the severity of the crisis in order to assist his political aspirations. So that might be an issue, but even in that case, states probably are on pretty solid ground if they've done things in a way that allows due process and allows proportionality. Moving on to the next slides. Yeah, so again, this is just continuing to talk about proportionality and also margin of appreciation. Many investor state tribunals have always taken an approach where they allow a certain level of deference when they're dealing with the state. Tribunal members are very reluctant to put themselves in the position of the policymakers, and with a hindsight that's 2020, say, oh, they should have done X and not Y. So because there is that level of margin of appreciation for the state and deference to the state in certain regards, they really don't try to second guess the policies of the state. And for that reason, there's likely to be quite a lot of room for give in interpreting the FET standard. On full protection and security, I don't think we'll see as many claims raised as this, just because there's not as many FPS claims. However, that standard does typically require a state to act with due diligence and due caution to protect investments. And more recently, that protection, because of the word full that's often in bilateral investment treaties, has been often extended from physical protection to legal protection. And security is often now not confined to physical security. So there is a chance that some claims might arise where a state or an investor might say that the state didn't take sufficient measures when the virus occurred, and that because of their delay and because of their failure to act, they essentially allowed the crisis to get a whole lot worse and to cause harm that otherwise wouldn't have happened to their investment. Again, there'll be some major causation issues in proving up that claim. Moving on to the next standard of expropriation, there's a possibility of arguing both indirect and direct expropriation. And a lot of times we're seeing this where, for example, some facilities are being entirely taken over by the state, for example, to produce PPE, to produce medicines and vaccines. So if there was an actual taking over the title of the investment or the asset without compensation, without due process, that very well could result in a expropriation. Again, it's going to be a balance between how the state applies this measure and whether the measure is proportional and allows due process versus the interests of the investor. And then going on to the next, I'll just quickly go through because I think my time is nearly up. There are also some potential national treatment claims. There have been instances where governments have treated their own citizens more favorably than foreign investors. A lot of times when the economy goes south, states will want to give preference to their own citizens in relation to the workforce, in relation to access to different government incentives and certainly bailout packages. So that's another area where one might expect to see some types of claims arising out of it. Moving on to the next slide, and really I'll end with this point. You know, as so much in our field, it really depends. So it depends on the nature of the measure. So was the measure, you know, really directed at facilitating and protecting public health? And how proportionate was that? You know, did the state do it with a scalpel, or did it use an axe? You know, was the measure so kind of discriminatory or arbitrary, or just caused unnecessary harm, or was it measured? And I think tribunals that eventually hear some of the COVID claims, and already, as you know, Olga had mentioned Peru and Mexico, we've already seen that. There has been an argument that those claims and those actions were already underway, and that states were already planning on, you know, carrying out this as part of their policies, another Boris Johnson bike problem. So if that's the case, and the true intention really wasn't focused on COVID, I think the chance of success is much more likely. And with that, I think I will turn it over to Olga B., who will talk about some of the defenses that states will have when faced with any of these claims.
Thank you, Sarah. That's perfect timing, which is also the sign of a great advocate. I'm going to indeed talk about the defenses that states can mount when faced with COVID claims by foreign investors. But before I do that, I quickly wanted to say hello. This is, after all, a coffee shop session, so it's meant to be interactive and informal. Hello, good afternoon to those zooming in from Moscow, and good evening to those who are zooming in from Hong Kong, like myself. And I see there are a few participants from Manila and elsewhere in Asia. Very good to have you here. Taking over from Sarah and from her overview of COVID-related claims, I'm going to talk about, again, defenses that states are going to put up if indeed faced with claims of that nature. But before I do that, there's going to be two caveats. And the first caveat is that despite, you know, the setting of the scene earlier today and the question that everyone answered on polls as to whether the ISDS system is well adjusted to deal with COVID claims and how this is all going to happen, the first caveat is that the world regularly goes through bouts of infectious diseases outbreaks. This isn't the first time, perhaps it's the first time in our lifetime when we're facing a pandemic, but such situations happened in the past. And the proposition that I have is that investment law is perfectly adjusted to deal with any potential abuses by the host states, and sort of Boris Johnson's bike abuse, and the investors are also very attuned to their rights, especially sophisticated investors. And the second caveat is that states are not defenseless when they're dealing with COVID claims, and that doesn't mean that states have carte blanche to just take foreign property and not compensate and claim that that was all done in the interest of the community and public health and security. There are limits to that. But that said, there are four defenses. There are four defenses that states would typically, and that's what we see from the past, that states would typically put together. And there's sort of two groups. The first group of those defenses would be based on the policy doctrine, police powers doctrine, and the second group would be based on customary international law, and that's the draft articles on state responsibility for internationally wrongful acts. So with that, what I'm going to do is I'm going to try and put up my presentation, and so that everyone can see it on the screen. Here you go. Oh, do you see that? Here. All right, here you go. So The first group of defenses that states are going to be able to put together would be based on police powers doctrine. And the police powers as a name of doctrine is sort of a bit misleading. Police in the sense of policy. Police powers doctrine means that if there is a measure that falls within the state's power to regulate within its own territory with a view to protecting public health and the environment, and that measure negatively impacts foreign investment, that measure does not give rise to any obligation to compensate. And that is going to be based on police powers doctrines. And that's the essence of the state. That's the prerogative of the state to take measures that are designed to protect public health and the environment, which is very relevant in the COVID context here. There were cases of this nature in the past, in particular, you know, back in the day, the smallpox epidemic, where, and that was obviously not a treaty case, but rather a case brought by a German citizen before the German Venezuelan Claims Commission. And it was an interesting case because in that instance, the German citizen had a carriage that was traveling in Caracas, and there are two passengers in the carriage, and the police intercepted the carriage and took it away on the assumption that the two passengers were infected smallpox passengers, and so they had to be taken away so that the disease wouldn't spread. And then following the investigation, it was discovered that the passengers were fine and the carriage was meant to be returned to the German citizen. But since it took a while to investigate and the carriage was left outside, there was all sorts of damage caused to the carriage, and the German citizen said, well, wait a second, I can't accept that. This is damaged goods, and you owe me compensation. And the German Venezuelan Claims Commission, in fact, found that during an epidemic of an infectious disease, there can be no liability for the reasonable exercise of police power. And the key word there is reasonable. So the police power doctrine is not unlimited. And that's not the only limit. So not only do the measures have to be reasonable, so Boris Johnson's obsession with bicycles would probably be unreasonable, but it also should be proportionate to the situation that the jurisdiction is facing. And also it has to pertain to the most serious issues of public policy, such as public health and the environment. And now, while that sounds somewhat non-controversial, in fact, it is not settled whether police power doctrine is part of customary international law. And even if it is, how it interacts with other doctrines, part of customary international law, such as the Hull formula, for example, that says that whatever the purpose of the expropriation, whatever the purpose of the measure, if a foreign property was taken away, the host state is liable to compensate foreign investors. So the sole effect doctrine there as well. And so in the latest treaty case law, in fact, police powers doctrine has been invoked by the states a number of times. There's an interesting Saluka finding here that says that basically the adjudicator will have to look into these measures in a case-by-case basis and see whether those measures actually cross the line from being legitimate exercise of the state's police powers and into treaty breaches. And so it would make, for the adjudicators, it would be much easier to arrive at the finding that a particular measure is non-compensable because it's taken within the police powers doctrine if the actual treaty, underlying treaty, allows or provides for that. And the contemporary treaty-making practice sort of addresses that issue with multiple carve-outs, such as environmental carve-outs, and you see here the COMISA Article 20 that provides that these types of measures are sort of not subject to compensation, do not constitute expropriation within the meaning of the treaty. The free trade agreements as well, you know, the most contested one with the demonstrations in Malaysia and elsewhere in the region, the Trans-Pacific Partnership Agreement does contain a similar carve-out as well. So for a tribunal sitting under that treaty, it would be easier to find that the particular measure is not subject to compensation if it was taken with a view to protect public health and the environment. Other treaties, potentially the largest one, the RCEP, that's hopefully coming soon, might contain similar carve-out. So that's the main sort of defense that host states can build. And the others are relatively straightforward, and they're based on the ILC, International Law Commission draft articles on state responsibility for internationally wrongful acts. And that is sort of straightforward: force majeure, distress, and necessity. But the problem, and I see very familiar names in the list of participants, so I'm not going to go into much detail on these defenses, but the problem with these three defenses is that they're also limited. And for the state to successfully claim these defenses, the state would have to reach a certain threshold. For example, for force majeure, the state would have to demonstrate that it's a completely unforeseen event. And as you know, there is a debate as to whether pandemics of this nature are unforeseen events, indeed, given that they have happened in the past. The state would have to demonstrate it was beyond the control of the state. You think about Trump and whether he had an opportunity to control the spread of the disease, having had all the information back in the day. That's also a question. And then the state would have to demonstrate that it would make it materially impossible in the circumstances to perform the obligation. So that's a high threshold. The distress as well, difficult defense to argue, but potentially possible. There, the state would have to demonstrate that the measure was taken with a view to saving lives or lives of other persons entrusted within the state, and would have to also demonstrate that if that measure wasn't taken, then it would have led to a greater peril or damage to life. And necessity, finally, is also not an easy defense to successfully argue, because there the state would demonstrate that the measure was taken with a view to safeguard an essential interest against an imminent destruction or peril, along with other issues. So to sum up, while of course there are legitimate grounds for foreign investors now to bring claims, COVID-related claims against host states, states are not defenseless, and investment law is indeed prepared to address those claims.
Okay, thanks a lot, Olga. I think we should now hear to Viktor Prokofiev, who has a question. Okay, Viktor, you can talk now.
Yes, hi. Thank you very much. I wanted to thank all the presenters. That was very interesting indeed. My question is for Olga Boltenko, if I may. That's with respect to the police powers concept that you referred to. You briefly spoke about that concept and also about force majeure and distress and necessity. I was wondering, my question actually is twofold. I was wondering, to what extent is that purely customary international law? Is that part of any conventions? Is that made reference to in the treaties? Or is this purely customary? And also, what is the interplay between, on the one hand, force majeure and police powers concept? Thank you so much.
Thank you, Victor. That's an interesting question, and in fact, this isn't settled in contemporary investment law, whether police powers doctrine forms part of customary international law. And that is because, as you know, there's a test that the particular doctrine needs to satisfy in order to be recognized as part of customary international law. You need to demonstrate opinio juris, and you need to show that the states would have acted as if, in a sense of legal obligation, in accordance with that particular doctrine. So that's also not an easy test to pass, and there's been case law where arguments have been made that police powers as a doctrine form part of customary international law. But either way, police powers doctrine is not invoked as part of treaty defense, as part of treaty-based defense. If it is invoked, it would be invoked, and I welcome views of my co-panelists, it would be invoked as part of customary international law, and there you'll have to demonstrate that it is indeed so. And then in addition to that, there are other doctrines that are potentially also customary international law that contradict the police powers doctrine, such as, for example, the sole effect doctrine or the Hull formula, which says, well, it doesn't matter why the measure was taken, as long as it damaged foreign property, there is an obligation to compensate. So this is an unsettled question in contemporary investment law, and I think if there is an option to invoke the ILC draft articles based defense, that would probably be a safer defense to invoke, because at the very least you've got the draft articles, and it would be easier to demonstrate the basis for that defense.
Yeah, I might just add one point on that, Olga, and I agree with everything you said. There's also some bilateral investment treaties have essential security provisions. So for example, the US-Argentina bit had an essential security provision, and that was invoked by Argentina in defense of its measures. And then there's a question, is that a self-judging provision, or is it judged objectively or not? So some bilateral investment treaties do have a so-called essential security or essential security interest provision, which could arguably be applicable in this instance. Also, interestingly, a lot of the newer generation bits, the newer model bits, have specific references to public health. So CETA, for example, specifically references public health as a key goal or objective of both parties. So I think there still is a real distinction, and claims might do better under certain treaties than others. But there will be aspects of treaties that will still make a real difference in this context, I think.
Yeah, I think it's when the defense is treaty based. When there's a carve out in the treaty, it's much easier for the tribunal to accept that, well, this measure is taken within that ambit of police power or measures that are designed to protect public health and environment and national security. And it's interesting that indeed, if you look at the latest generations of BITs and free trade agreements, you almost always have that carve out. The TPP definitely has that carve out of whatever form it has now taken. But there are other free trade agreements, such as, for example, this regional comprehensive economic partnership agreement that is going to be massive once it's concluded. The interesting part is that obviously the negotiations are kept confidential, and we don't know what the drafts are and whether they're the extent of those carve-outs in that treaty. But chances are that this isn't going to be the most environmental treaty of all, because of the negotiating states. China, for example, is not particularly, keen on such provisions. So it remains to be seen. But the general trend, I think, is this green multilateralism, where the treaties, contemporary treaties, would have this sort of carve out. So with that in mind, it appears that contemporary treaty making practice does or is designed to address situations of major public health concerns, as we're facing now.
Okay, I think we have a time for a couple of more questions from audience. Okay, I don't see those so far, but okay, then I actually wanted to ask you a question as well, to both Olga and Sarah. You mentioned that investment law is perfectly fine with dealing, as I understand it, with pandemic disputes. I question that, because those standards were developed completely out of the context of current new, quite substantial challenges. And many of those standards, as Olga mentioned, actually, and Sarah as well, actually quite, either vague, or tribunals have really big discretion and actually no big guidelines and guidance in current circumstances, neither states, when they had to act, they acted without almost complete data available. And some, for instance, international organizations issued recommendations against travel bans and border closures, calling them measures taken out of fear, and basically calling them unreasonable. So how tribunals should judge what is reasonable, what is adequate in those circumstances where states just do not have enough information to act?
Yeah, I think this is where the margin of appreciation would come in. And if there wasn't sufficient information at the time to understand the full implications, I think a state would be forgiven for potentially, implementing a policy that maybe could have been done a bit more delicately. That being said, I think there has to be a rational link between the objective of the policy and the measure at hand. So I think, some states have used this to, make amendments to constitutions to essentially allow the state to have unprecedented police powers for monitoring their populations, for tracking different individuals, a lot of times political advocacies. I mean, these types of things, I think one could argue have gone above and beyond what was necessary to address the pandemic. So I think it will really be, like most of our cases, a fact-specific analysis and a judgment of the reasonableness and the proportionality of the policy implemented against the rights of the investor. But I think because this has been such a, global crisis, it is closer to everyone's home, if I can say that. And other states will also be worried about their interests and whether or not they will be sued as well. Olga, did you want to add on to that?
Yeah, I was just thinking in terms of the measures and the potential claims that the investors could bring. It's not only the reasonableness and proportionality. I think in light of what happened during the pandemic, we see that the governments take measures that are blatantly discriminatory. For example, they would subsidize a particular industry ahead of other industry, or they would favor local domestic investors ahead of foreign investors, creating this uneven playing field and thus causing some sort of destruction to foreign investment. So I think the measures that the states take during the pandemic do really need to be balanced out against the existing treaty network and international law. While it is clear that the governments are trying to save struggling industries, but would that really be justified to say, well, we're just going to save our domestic investors and we're going to make it impossible for foreign investors to continue operating? Would that then be a breach of national treatment provisions, for example? So I think in addition to reasonableness and proportionality, the governments would have to keep in mind the discriminatory nature of potential measures and be very careful about that, because that's very easy to prove, as opposed to reasonableness. What is reasonable in light of a situation where nobody knows what's going on, how infectious this is, how many people are going to die. Whereas if it's discriminatory, it's out there.
Okay, thanks, Olga. We have Peter Woolrich also raising a hand. Peter, you can talk now.
Okay.
Hello.
Can you hear me?
We do hear you, yeah.
Very good. Thanks, Olga, for this very interesting session. My comment would be the following thing, and I don't think this is contradictory to what has been said. There are some 3,000 bilateral investment treaties out there. And very few of them specify clear guidelines or definitions as to what FET means or as to what full protection and security means. Very few of them have carve-outs which specifically refer to states' rights to exercise police powers and then indicate under what circumstances. And the ISDS system, as we all know, is one that totally lacks stare decisis. And so you're going to have individual tribunals throughout the world using different BITs and coming up with different answers with no body behind them to determine once and for all what the rule of law on this topic is. And so, to my mind, ISDS is totally unprepared for this type of dispute, as I think it's totally unprepared for many other types of disputes, but particularly this type.
Thank you, Peter. That, to some extent, I think, echoes my concerns.
Yes, I know.
Okay. Do we have any other questions? I think we have comment from Alisa Protasova in chat. We are going to read it. And while we are reading, we have just 4 minutes now before the end of the session. And I think it's a good time to relaunch a poll, especially after Peter's comment. And probably it will affect somehow results. So I'm going to relaunch it. And now, okay. I guess, yep, you can vote once again. Please do.
It looks like Peter's comment sort of tipped the balance.
Okay, I think audience does not see results so far. So, okay, I've shared, yeah. So Peter, the audience is yours.
I had no desire to people, but just to express a view. Absolutely,
and I think Alisa's comment also raised a concern about how predictable, because tribunals can be, because it's not only a question of a particular dispute, but also measures, some guidance for states for future, because they will be required to take further measures. And in the absence of, predictability, it's just difficult to react in such circumstances.
Exactly right.
The other thing that we really haven't talked about yet, but it's also enforcement. And if you were to get an award in your favor as a foreign investor on, resulting from actions taken out of the pandemic, having it come in relation to a pandemic might make enforcement a bit more tricky, because there is a chance, maybe a higher chance, that a court at the seat might turn over an award based on public policy issues. So I think that's another. I always think in the context. I do a lot of third-party funded work. And I always think in the context of enforcement and how likely am I to get paid in light of a favorable award. And I think that's another wrinkle that cases being brought that are related to the pandemic might have.
Yep, I think that's true. So unless we have any other questions, yep, I think we want to be a good panel, and end in time and allow, other, I don't know whether we have sessions after us, but in any event. So we just want to thank you so much, everyone, for participating, for, taking this quite challengeable format of online sessions. It was a pleasure for us, and we hope to see you sometime soon in person. And with that, I think we can end the session. Thank you very much, everyone.
Thanks, everybody.
Thank you. Thanks, everyone.
Bye.